And so now we are here on Pope versus Mitchell. So Mr. Oliver, again, this looks like a post-foreclosure dispossessory. I do understand that Ms. Mitchell, you are contesting the underlying foreclosure. But that, I just, in terms of my understanding of the law, that the disputing the foreclosure itself is going to, you're doing that in Superior Court or somewhere else, but that doesn't, it's not going to be, that in and of itself would not be a defense to the dispossessory. Okay. So if they have a valid if they have a valid deed to the property and they can show that they made demand for the property, they can show both of those things, then they're probably going to be able to get possession. But I'll go ahead and listen to what everybody has to say and see whatever documents come in, and we'll go from there. Okay. So Mr. Oliver, so is your
okay.
Go ahead.
Yes, Your Honor. Initially, we'd be asking for a judgment on the pleadings. We are wholly unaware of any foreclosure proceedings.
I mean, unless I'm insane, I think did you not read? I mean, it's in I think it's in her answer. Am I mixing this up with something else? I thought that's what it said.
I think you may be, Your Honor.
All right, hold on a second. I'm sorry. My apologies if that's the case. No, it is. No, she put on her answer, see attachment, and then there's numerous documents regarding she's made all mortgage payments and HOA payment.
Yes, I have that, but with respect to information about it being foreclosure, I'm wholly unaware of.
Oh. So I'm confused. If she's making all the mortgage, wouldn't you own the property if you're making the mortgage payments? She's making, yeah, yeah, because she's saying she's making all the mortgage payments.
Correct.
To a property she doesn't own.
That is correct.
Okay, this is not quite as simple as I thought it was. All right, go ahead.
Well, I mean, I can clarify for you, Your Honor.
Okay.
The property was originally owned, and with respect to my request for judgment on the pleadings, I'll be brief. The property was initially owned by Mr. Jeffrey Pope, who expired in April of 2024. Miss Celestine Benjamin, who is the witness here today, and I believe is the defendant's aunt, was the administrator for Mr. Pope's estate. While during the administration, Miss Celestine Benjamin transferred the interest to Miss Gwendolyn Pope, who is the natural heir of Jeffrey Pope. And during that time, Andrea Mitchell occupied the premises from at least May 2024 until August of 2024. I believe that in Miss Mitchell's answer, she has vacated the premises as of August the 10th. Mr. Pope or Miss Pope do not have access to the property and cannot verify that. Verify whether she has vacated the premises. But the tenant agrees that she has been paying money to the mortgage company. However, she has not paid any money to the landlord, who is Miss Gwendolyn Pope. Miss Gwendolyn Pope has no information about the mortgage.
I don't see Gwendolyn Pope here.
She is not here, but Your Honor, Mr. George Pope is acting on Gwendolyn Pope's behalf, has filed a power of attorney with the court.
He can't be, I mean, he's not the owner of the property. I mean, he's not the client, he could be a witness, but he can't represent her.
Correct. So Gwendolyn Pope is suffering from some mental deficiencies, unfortunately. Mr. Pope has power of attorney over her. She has authorized him to handle her real estate affairs. I'm sorry, who's missing?
I think it's someone on there. Now they're not connected to audio anymore.
Okay.
Hold on a second. Their connection is not great. Miss Mitchell, do you hear me?
I'm here.
Have you already vacated the property?
Yes, ma'am.
Okay. So at the end of the day, I guess I'm wondering why.
Yes, ma'am. I have
Say that last part again. Say that last part again.
Yes, ma'am. I vacated on August the 10th.
Okay. What's the holdup then? If the defendant's already vacated and this is just possession of the property. I mean, it's not.
Yes, no money damages. We're willing to amend it and dismiss the claim for money damages. We're just asking for a writ of possession.
Okay. So if you've already vacated, Miss Mitchell, it doesn't sound like there's really anything else to argue about. Because if they're not seeking any sort of financial,
Yeah, I'm just asking them to dismiss the case.
Okay, how about, why don't we do, let me ask you this. So if you're saying you vacated and you guys just want to verify that they vacated, is that right?
Correct, Your Honor.
Can we come to an agreement where they can go, if you guys want to go and give them access to the property just for the sole purpose of seeing if you guys have vacated? And then we can just come back, and if they vacated, or you guys can just dismiss this thing? I mean,
That was
Is
the
that-
intention. That was our intention. That was what was presented in the breakout room.
I mean, if you're only, because it doesn't sound like there's anything to really argue. If you're already out, all this other stuff is not something I could deal
Yes,
with anyway. It's just
I
possession.
provided
You provided what?
I provided documents stating that I provided text messages from the movers that helped me move on August 10th.
But they just want to go in and just, again, they just would just like to go in and see and make sure that you vacated. Do you still have keys to the property?
Yes. No, ma'am. I
that's-
told him I left the keys in the town.
Keys in the what? You left keys where?
In the townhome.
And it's locked?
On the property.
Inside the property.
How can they get keys
Yes.
to it then to get in there? Miss Mitchell, can you
They
hear me?
probably had to call a locksmith.
They're going to have to call a locksmith.
Yeah, I heard you.
Okay. So are you agreeing that they can,
Yes,
are you,
I didn't know where to
since
leave
you're
the keys.
out of the property, are you, okay. Are you going to, it doesn't make any sense to me, if you're already out of the property, why you wouldn't just let them have a writ and get back in the property?
They didn't give no instructions.
They didn't give me any instructions.
we-
I was just left with an eviction notice on my door.
Well,
Why don't you guys take 5 minutes? Because this does not need to be a hearing. If you're out already, there's no reason why we're having a hearing right now.
Yes, ma'am.
Your Honor, I have presented a consent agreement with this understanding that they turn over the property, we get access to the property, and we will dismiss
Yeah.
the money damages claim.
He just wants
And
access to the property, which
that's
is
all I'm
something-
asking for.
You're already out. I think, why don't you guys take 5 more minutes, go back in a breakout room, despite we were, I do need to get out of here at noon, but I will put you back. I mean, it just doesn't sound to me like this needs to be an issue. If you're already gone, I don't see why, and they're not seeking any sort of financial judgment, then I don't see why we're going through all this. But I'll put you, why don't you guys go back in the breakout room, take 5 minutes and
Thank you.
Come back. Okay.
Thank you, Your Honor.
All right, Mr. Oliver, it looks like everybody's back. Were you guys able to resolve it?
Well, no, I presented her, Ms. Mitchell, with a consent agreement that says that she turns over the property. We agree to drop our request for money damages. She does not want to sign it. We're still asking for a writ of possession.
All right,
Which
Ms.
is
Mitchell,
essentially the same outcome.
why are you objecting to giving up possession of the property if you've already moved out? What defense
Your Honor,
do you
I don't
have
feel like
against? What?
I don't feel like there's no point of signing it if I've already told you the keys. I don't have possession of the keys. She already owns the property.
They just want to be sure that they can legally access the property. Okay, you're going to be forcing them to go through a lot of extra steps. I mean, and that's fine if that's what you want to force them to do, but it's like, if you're already out,
Right.
it doesn't personally affect you in any way. You're just going to make them wait for a writ before they can actually get in there. It could take like a month or something, it could take a long time to get in there. I mean, if you're already out, I'm not sure why you would want to do that, but if that's what you want.
I just don't feel comfortable signing it.
All right. So, so I don't think Mr. Pope can really he's not your client. Ms. Gwendolyn is the client. So you'd have to show, I guess, again, motion on for judgment on the pleadings for just possession only. So if you want to go ahead and make your case for that, Mr. Oliver, you can go ahead.
Okay, again, Your Honor, Mr. George Pope filed on behalf of Gwendolyn Pope, who is the property owner of 2746 Vining Ridge Terrace in Decatur County. I'm sorry.
I guess so, Mr. Oliver, this is my concern. I guess he is, it really should have been Gwendolyn Pope as the plaintiff.
Well, it's Gwendolyn Pope for Gwendolyn Pope is how it was titled.
Okay, it's hold on. This says George Pope
I'm
versus,
sorry, George Pope for Gwendolyn Pope.
right, but unless he has adult guardianship over her, he can't be the plaintiff. I mean, he can't. He's not the plaintiff. He's not the owner of the property. He's not the plaintiff.
Correct.
I mean, he could still, if it was like the estate or you know, estate on behalf of, or I just don't see how he can be the plaintiff in this case if he doesn't own the property.
Okay.
He could be the. I mean, that doesn't make any. I mean, are you saying you understand what I'm saying? Like,
Yes.
He's not the plaintiff, and he's listed as the plaintiff. So I don't think the proper party is listed here.
Okay.
So, if you want, I can, you know, I typically dismiss these. If you want to take a couple weeks and amend your, you know, I don't know if it'd be easier for you to just dismiss and refile or.
Or I can amend, Your Honor.
Okay. Why don't I just reset this 2 weeks? In the meantime, Ms. Mitchell, if you want to talk to them, you might not, you know, anyway. And you can amend it since you're not seeking a money judgment anymore anyway. You could amend it for that purpose too, just to kind of take
Okay.
that part off of it. So, so I mean, we'd have to reset. I mean, you'd have to like refile, get it served, wait the 7 days. I mean, it almost makes, I mean, or in terms of amending it, you're going to have to still wait for them. I think what I'm going to do, Mr. Oliver, I mean, I think I'm just going to, I typically just dismiss these for failure to name for parties. So I think that's what I will do today, but you can
Okay.
file and we'll get it on the calendar as soon as we can. Okay.
Will do.
All right. Thank you, sir. All right.
All right. Thank you.
Have a great rest of your day.
All right.
Thank
You too. Bye-bye.